I'm going to read some law for you. It's not very complicated. It's called the Lanterman-Petris-Short Act. It's a part of it, Section 5326.5, Section B. The physician may urge the proposed treatment as the best one, but may not use in an effort to gain consent any reward or threat expressed or implied, nor any other form of inducement or coercion, including, but not limited to, placing the patient in a more restricted setting, transfer of the patient to another facility, or loss of the patient's hospital privileges. No one shall be denied any benefits for refusing treatment. Now, when we bring up issues such as those addressed in the LPS Act, we're told that we do not belong to the LPS class of patients, and therefore we do not have those rights. The Lanterman-Petris-Short Act, the LPS Act, is obviously meant to protect the patient from the institutional mental health caregivers. One does not have to look back in time very far to discover psychiatric abuses against patients in mental hospitals. Such persons are utterly at the mercy of their keepers, who even have the power to structure how patients are perceived by the public. The absolute power of credible accusation the Department of Mental Health wields places them at such an advantage that these victims have always needed a shield. Now, if you're old enough to remember the old Soviet Union, perhaps you can remember how dissenters were removed to the gulags under the aegis of psychiatric diagnoses. Psychiatry has been guilty of many such abuses and others besides, such as forced medication, electroshock therapy, and lobotomies. Perhaps you even think that these kinds of abuses could not have happened in the United States. However, then you'd have to explain why lawmakers wasted so much good paper and ink crafting such a law as the one I just read to you. The Soviet Union system is disbanded, but not psychiatry. It is in state-run psychiatric institutions that abusive treatment creeps in. It's easy to forget that they're there. Government watchdogs are often distracted. The LPS Act was created to end abuses that were already happening. In the time that has passed since the establishment of this act, have conditions changed such that the protections it afforded involuntarily committed persons are no longer needed? Has there been an unnoticed and profound change in the nature of mental health workers or in state mental institutions? These people were so bad that the legislature had to write a law prohibiting their coercion and bribery of mental patients. How well have they been following the LPS Act lately? Here's how well. While no one was looking, they created an entirely new class of mental patient and excluded them from the protections afforded by the LPS Act by declaring them non-LPS patients. Is there anything that distinguishes an LPS patient from a non-LPS patient? If the legislature found it essential to protect involuntarily committed persons from their keepers due to an understanding that they had no power and could not defend themselves, by what logic can it be said that SVPs, the most reviled population on the planet, have more power to defend themselves? Is there anything about the LPS Act that you would consider inappropriate treatment for anyone? What sort of person would want to remove the ethical protections governing coercion and bribing? And what exactly has happened after those people removed from themselves these safeguards? Bribery, special conditions and privileges for treatment participants, and coercion, removal of hospital privileges for those who decline to attend their wellness and recovery team meetings, treatment. Are the LPS statutes aimed at patients, or are they aimed at hospital employees? They are aimed squarely at mental health workers. Patients only come up in the statute as victims to be protected. Who is it then that decides to declare this small population as their unique possession for special treatment? It is the very ones from whom the legislature sought to protect the patients in the first place. Imagine that. Here we go again, right back where we started from, with the so-called patients needing protection from the so-called fine institutions staffed by those ardent healthcare providers. Surely with their passing, all compassion will cease. When the LPS Act declares it unethical to, quote, use in an effort to gain consent any reward or threat expressed or implied, nor any other form of inducement or coercion, including but not limited to placing the patient in a more restricted setting, transfer the patient to another facility, or loss of the patient's hospital privileges, does the hospital really think that the legislature differentiated between one class of involuntarily committed person and another? Since the Department of Mental Health was being restrained from abusing patients, how can they be the ones who declare that one group of patients is exempt from this protection? That is the exact equivalent of saying that they are redefining what it means to be an involuntarily committed person. What if a killer simply redefined his victim as someone not protected by the law? And what if they defined your citizen what a citizen is?